Copy- Copyright fair use, analyzing New York Times versus OpenAI and Getty versus Stability AI. Can artificial intelligence legally train on copyrighted works without permission? When an AI models ingest billions of news articles or copyrighted images, is that innovation or infringement? Today I will talk you through two landmark cases shaping the future of AI and copyright: the New York Times versus OpenAI and Getty Images versus Stability AI. These cases may define how fair use applies to generative AI. What viewers will learn, what these lawsuits are about, how US copyright law defines fair use, the legal arguments from both sides, why training data is the central battleground, and broader implications for media, artists, AI companies, and innovation. Background: how generative AI uses copyrighted works. 1. How large language models and image generators work. Generative AI systems. These are trained on vast data sets scrapped from the internet. They learn patterns from text or images and generate outputs based on statistical associations. Training typically involves copying content into data sets, tokenizing, analyzing it, adjusting model weights based on patterns. 2. Why copyright issues arise. Key legal concerns: were copyrighted works copied during training? Does temporary copying count as infringement? Is training transformative under fair use doctrine? Do outputs reproduce protected materials? And this is not merely about outputs, it is about training itself. The legal framework: US fair use doctrine. Under US law, fair use is analyzed under 4 statutory factors in Section 17 of the SS Copyright Law. 1. Purpose and character of the use. Cost asked: is the use transformative? Is it commercial or non-profit? Transformative use means the new use adds something new with a different purpose or character. 2. Nature of the copyrighted work. Creative works receive stronger protection than factual works. 3. Amount and substantiality. Did the defendant copy the entire work? The heart of the work. AI training often involves copying entire works, raising concerns. 4. Effect on the market. Does the use harm the existing market for the work or potential licensing markets? This factor often carries heavy weight in litigation. The New York Times versus OpenAI. Case overview. In late 2023, the New York Times filed suits against OpenAI and Microsoft in federal court. Core allegations: OpenAI used New York Times articles without authorization to train its models. ChatGPT allegedly reproduced verbatim or near verbatim passages. The conduct allegedly harms New York Times subscription and licensing markets. The New York Times legal arguments. New York Times legal arguments: unauthorized copying for training. The complaint alleges large-scale reproduction of copyrighted articles. Even if immediate, copying may infringe their rights. Non-transformative commercial use. OpenAI is a commercial enterprise, and New York Times argues the use substitute for the original journalism. Market harm. AI-generated summaries may reduce subscriptions. Potential loss of licensing revenues to AI developers. Output reproduction. Instances where ChatGPT allegedly reproduced full or near full articles. OpenAI's defense teams. Although litigation is ongoing, key arguments likely include transformative use. Training AI models is not republishing articles. It extracts patterns, not expressive content. Analogy to search engines. Courts previously held search indexing and caching can be fair use. Public benefit and innovation. AI systems provide socially beneficial tools. Output safeguards. Efforts to prevent verbatim reproduction. Why this case matters? This case may determine whether training on copyrighted news is fair use, whether AI companies must license journalistic content, whether outputs triggering memorization liability affect training legality. Getty images versus stability AI. Case overview. Getty images sued stability AI in 2023 in the US and United Kingdom. Core allegations. Stability AI copied millions of Getty's copyrighted images. The AI model allegedly reproduced Getty watermarks in outputs, and no license was obtained. Getty's legal arguments. Mass copying for commercial use. Entire images were allegedly ingested into training data sets. This copying was commercial and systematic. Watermark reproduction. Generated images sometimes display distorted Getty watermarks and suggest memorization and reproduction. Market substitution. AI-generated images compete with licensed stock photography. Stability AI's defense teams. Likely defenses include transformative nature of training. The system does not store or distribute original images. Training transforms images into abstract numerical representations. Fair use precedent. Prior cases allowed copying for machine analysis. Lack of substantial similarity. Outputs are newly generated works. Key legal issues in both cases. Is training itself infringement? Central question. Does copying works into training datasets violate copyright? Some courts have allowed immediate copying if transformative and non-expressive. But AI training differs in scale and commercial scope. 2. Transformative use debate. AI companies argue that training is transformative because it teaches statistical relationships, while right holders argue that it competes directly with original markets and it replaces demand. 3. Memorization and output similarity. If AI outputs reproduce substantial portions verbatim, liability risk increases significantly and cost may distinguish training legality and output liability. 4. Licensing market impact. A major factor here, if AI developers could reasonably license the works, failure to do so may weigh against fair use. International dimensions. The UK and EU frameworks differ significantly. The UK initially proposed broader text and data mining exceptions, but reconsidered it, while the EU allows limited text and data mining exceptions with opt-outs. Getty UK. The Getty UK litigation may influence global outcomes. These cases may result in divergent transatlantic copyright regimes, as well as global licensing frameworks. Industry implications. 1. Media companies. Potential outcomes include licensing deals with AI firms, new revenue streams, and stronger enforcement regimes. 2. AI developers. Possible consequences. Mandatory licensing models, higher development costs, and slower innovation. 3. Creators and artists. Impact includes economic displacement concerns, litigation leverage, and calls for compensation schemes. Policy and future directions. Possible outcomes include 1. Cost rule training is fair use. 2. Costs require licensing for copyrighted data sets. 3. Hybrid model, training permitted but output liability enforced. 4. Legislative reform clarifying AI training rules. These cases may become defining precedents in AI era copyrighted law. In conclusion, New York Times versus OpenAI and Getty versus Stability AI are not just copyright disputes. They are foundational tests of how intellectual property law adapts to machine learning. The question is whether fair use can accommodate AI training at massive scale, or whether the law will require a new licensing ecosystem. These cases will continue to shape the economics of journalism, stock photography, and AI development for decades.